My client told me he would not take less than $1 million to settle this case. You want to learn why my client finally accepted not just substantially less, but a fraction of that amount of money? Come join me for a walk near the beach with my daughter Mia as I explain the answer about what happened here. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Mia is a second-year law student. She's joining me on this walk today, and hopefully it'll be interesting and eye-opening, because in this case that I handled many years ago, it involved a medical malpractice case involving my client, and now the defense refused to negotiate. As we got closer and closer to trial, the defense reached out to me and said, hey, listen, is there a chance that we might be able to resolve this case before going to trial? And I said, yes, let me talk to my client and I'll get back to you. So now I went to my client's home and I actually had a very lengthy discussion with him. And now he tells me straight out, he says, I will not accept anything less than $1 million to settle this case. Okay, so at least I knew where he stood. But there was a problem. The problem was, in my opinion, his injuries were not worth $1 million. I had done significant research beforehand to evaluate the full extent of his damages and his injuries. And at best, I thought his case might be worth maybe $750,000 on a great day, okay? And I explained that to him. He didn't care. Instead, he said, I don't care. I will not accept less than $1 million. I said, you do realize that if the defense comes in with anything less than that, you are now forcing me to go to trial. He says, I don't care. I want a jury to put a number on my case, and I know they'll come back with more than $1 million. I said, okay, but do you also recognize that there is the significant possibility that a jury could come back and give you substantially less than what you are asking for? And he didn't believe that. I said, yes, it's true. Even though you think you have a great case and you have great experts and you feel your case is worth at least $1 million, a jury could come back and say something totally different. A jury could come back and say that you don't have a valid case, which means they would throw your case out without giving you a dime. On the other hand, the jury could come back and say, you know what? You do have a case, but we think your injuries are minimal, and give you something small or negligible, maybe $50,000, maybe $100,000, and now you're stuck and you've got a problem. Or they could come up with anywhere in that range. In fact, the reality is, when you go to trial, you as the injured patient have no idea what a jury is ultimately going to do. I don't know it, you don't know it, the defense attorney doesn't know it, the judge doesn't know it. It's only the jury who's going to decide what your injuries are worth if, in fact, they determine that you do have a valid and meritorious case. So now let's get back to the question I raised at the beginning, which was, Mia, what's going to happen if now my client says, listen, I want $1 million to settle this case? So the defense comes back and they offer a substantial amount of money. They offer about $300,000. Now, is that acceptable to me? No, it's not. I thought the case was worth much more. They come back and they say, listen, your client has a problem. I said, what do you mean? And now they begin to lay out in detail what my client's problem was that I did not know about. Now I have a total poker face when I'm learning this information from the defense. I don't make any reaction whatsoever, but the information I am now being told by the defense attorney is devastating to my client. This is something that has not been explored yet with my client. So now my obligation when I get a settlement offer is to go back to my client and to now discuss the risks, the benefits, and the alternatives of either accepting the offer or rejecting the offer. And that's exactly what I did. I made an appointment, I went to see him at his home, and now I sat down with him and I told him about the offer. And he said, listen, he was disgusted. He was insulted. He felt so disgusting by this offer that it was so cheap and insufficient to justify any further discussions. So then I sprung it on him. I said, let me share something with you and ask you a question. Were you involved in this particular situation? And he looked at me, his mouth dropped open, and the first thing he said to me was, how did you learn that information? I said, I'll tell you how. I learned it from the wrong source. I learned it from the defense attorney. I should have learned this information from you years ago. You failed to tell me about this, and now you have sabotaged your own case. You have literally undermined your own case for not disclosing this critical information that we could have dealt with earlier in the case. And now it's coming back to bite you in the butt and explode in your face. And as a result of that, the defense made very clear that you have significant liability and, importantly, credibility problems. And you might be thinking to yourself, what's the big deal? Why is there an issue here? I'll tell you why. Because there was an issue involving my client's past history. To be clear, involving his past criminal history. And there were things that occurred during these criminal events that my client failed to tell me about, and my investigation failed to reveal. And as a result of that, now my client's credibility was severely in question. And in case you don't know, in these medical malpractice cases, in these accident cases, in these wrongful death cases, when you go to trial, your credibility, you, the injured patient, your credibility is the most important aspect of the entire trial. Not the experts, not the attorneys, it is you, the injured patient. It is your credibility that matters most. And if you start your case where your credibility is shot, or you have no credibility because of something that happened that you failed to disclose, intentionally failed to disclose, now what you have done is you have dug a big hole for yourself. And it's going to be very, very challenging and difficult to extricate yourself, to get yourself out of that hole, to establish that you are trustworthy. And this really wasn't such a big deal. But doing that is no simple task. So in this instance, when I confronted my client with this information, he wasn't angry about what he had done or the fact that he had failed to disclose this information to me. He was angry that I learned about it, and that I learned about it from the defense. And I told him straight out, no punches pulled. I said, because of this, because you failed to disclose this information to me, and because you lied about it at the time of your deposition, now the value of your case has diminished significantly. And you think your case is worth $1 million? It's not even worth a fraction of that at this point. All because you failed to do what I specifically asked you to do, which was, tell me about anything in your past, tell me about anything in your history that could be damaging. And you intentionally neglected to do that. So what does that mean for my client? What did it mean for my client? It meant that the offer that came in was substantially lower than what we felt the case was worth. Did the case ultimately settle for $300,000? No. It settled for a bit more, but nowhere near what my client thought his case was worth, all because of his own sabotage. All because he failed to provide me with information that we could have easily dealt with during the course of his deposition, because it had nothing whatsoever to do with the claims he was making in this case, had nothing whatsoever to do with the injuries he was claiming in this case, and then it had nothing to do with anything in this case except his credibility. Because one of the first things that happens in these lawsuits is the defense goes ahead and does a background search, a criminal background search, and if they find that you have been convicted of a crime and you lied about it during your deposition, guess what? You have now significantly impaired or destroyed your credibility. So why do I share this quick information with you? Mia, you want to tell me? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. The reality is, I understand you're watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and your matter happened in New York and you're thinking about bringing a case but haven't done so yet and now still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.